1909, when the 1909 Act was put in. And 314 this is the beginning of PI, and that is the acronym for where I work, so I threw that in there for you. So I wanted to give you a little refresher over why register. So obviously it's voluntary, but it's got a bunch of benefits for you. So it gives a public record of the copyright claim, which is good for everybody. It gives you prima facie evidence of the things on the certificate if you register within 5 years. It gives you the possibility of going for statutory damages and attorney fees if you do it within a certain time frame. And you can record it with customs to deal with border issues, and it lets you file a lawsuit if it's a U.S. work. If it's not a U.S. work, you've got the Berne Convention, you don't actually have to do it. And in fact, you don't need to get a registration for us to be able to bring a lawsuit. We can refuse your registration, and you can still go. You might have a little bit of a harder time convincing people about your copyrightability, but, it's still an option. There is one thing I wanted to mention about the registration system in lawsuits right now, and there was a Supreme Court case called Fourth Estate that came out this past spring. It resolved a circuit court split that was about when you could bring your lawsuit, whether it was the application rule when you applied or if you had to wait for a registration decision. And the Supreme Court, I have Ruth Bader Ginsburg there, Justice Ginsburg, because she is the one who authored the opinion. But the registration rule prevailed. So henceforth, if you want to bring a claim in federal court, you must get either a registration or a refusal. So it's not just the application. That is something to really think about in your practice if you are contemplating the timing of filing things. I have a little quote under Justice Ginsburg saying that delays are attributable in large measure to staffing and budgetary shortages that Congress can alleviate, but courts cannot cure. So we were happy to hear that Justice Ginsburg understands our budgetary needs. Then we also keep you guys up to date about how long it takes to register. And we actually just released their new processing times. I guess it was Wednesday. We do this every 6 months. And so we keep going down, which is great. And so for online claims where we don't need to correspond, it's down to 3 months of an average. And for mail, it's down to 6 months. So it depends on whether we need to correspond with you and whatnot and the medium you use. But we are really working on it, and we've made a very big push to reduce our registration times. And there are 2 other ways to register if you are or try to get your thing through speedily. So one is pre-registration, which not many people use, but is a great tool. It is for things that might have a pre-publication infringement, which is pretty broad at this point. And so all you have to do is you file a very kind of abbreviated thing. Like if it's a film, you can do a treatment. You don't have to be finished with your thing. And we pre-register it. You can go to court with that. And you have to follow it up with an actual registration, but you don't need to wait the whole time. We also have special handling. So for an extra fee, I believe right now it's $800, you can seek expedited handling of it if you're about to go to court. So there are 2 options if you are concerned about the time. And with that, I have another quiz for you guys. So say you apply to register your work, and we refuse to register it. How many times do you have, how many bites of the apple do you have? Can you appeal to us twice, 3 times, 1 time, or none? Who thinks 1 time? Okay, who thinks 2 times? Who thinks 3 times? And who thinks we are very draconian and none? Okay. The answer is 2. So you can have two bites of the apple, so to speak. And our reconsideration process, so the first time you request reconsideration, it's actually going to stay in our registration program. We have a lawyer there who goes through all of the arguments and whatnot and decides whether or not it will go farther. For those of you who have received refusal letters from us, you know that the first one is kind of short. It gives the reasoning, but it's not, opinion length. And if you go ahead and you get refused, the first refusal is a little bit longer, and it gives more case citations and whatnot. So if you still get refused, you can go to the review board, and the review board is a 3-member board, which is right now it is the register, the general counsel, and me. And we basically vote on whether or not to register. It's a majority opinion. We do have a lot of discussions about it and a lot of debate sometimes. And the decision is final agency action, which means that is it, the end of the road for the Copyright Office. But you can bring an APA claim if you so desire. People do that occasionally, and we usually prevail in those. But you are welcome to take it up with the court, or you can always just go to court without that and try your luck and see if the court thinks that it's copyrightable. And I wanted to kind of give a little comparison to the Trademark Trial and Appeal Board and us and what we can and cannot do. So what can we do at the Copyright Office? We can analyze copyrightability. We can review legal requirements to see if you have done all the, abided by all of our regulations and requirements. We can see if, it is following the forms that you need to follow. We can make amazing decisions, which we always do. What we can't do is we can't resolve competing claims of ownership. We don't have that capacity. We cannot allow third parties to come in and attack applications or registrations. If you want to do that, you're going to have to go to court, or you can file kind of an adversary claim, but it's just on the record. We won't decide who is the actual owner. And we have a lot of different things that we do at the board. Most of our stuff is pretty routine, but some of it is a little more interesting. So I wanted to ask you guys what you thought. Which one of these is not the subject matter of a review board letter, and it's since 2016, because those are I don't want to throw anyone from the prior board under the bus. So the first one's a dinosaur skeleton. The second one is a sports logo. The third one's a patent application. And the fourth one is a genetically modified plant. So who thinks we have not dealt with dinosaurs? Well, you guys are smart. Who thinks we haven't dealt with sports logos? Who thinks we haven't dealt with patent applications? And who thinks we haven't dealt with genetically modified plants? Aha. Well, you are correct. It is genetically modified plants, but I have news for you. Oh, I can't show it, but we actually have done a genetically modified animal. So a fish that was modified to be glow in the dark, and we said no to that one. So we do come across some interesting things. Our review board issues, we usually are determining copyrightability. That's kind of the bread and butter of the board. And we also are frequently looking at visual works because they seem to be the one that keep a little bit more concern about whether you can do it. It's harder sometimes to determine whether those are copyrightable. We also look at things like older requirements from prior law. So, for example, we had one about a copyright notice on a piece of jewelry, where we had to determine whether or not the notice was proper under the prior law, which was actually a very interesting experience. And we do a lot of logos and computer programs, that kind of thing. And we do have some unique ones like dinosaur skeletons, sunsets, architectural works, and sound recordings. So we do have a kind of a good mix of some things that are, more routine and some things that are hard and kind of on the cutting edge of copyright. I wanted to give you a little bit of a tip on what to do if you are ever to come before the board and what you might want to put in your request for reconsideration. So make sure that you address what the first final refusal said. We want to make sure that you address those points and make sure that you have some good support for it, have some legal authority. And if you think we've missed something, then please bring it up. So if you are saying that you have a flower and it's got these stripes and we don't ever mention the stripes in our first refusal, you might want to say something in your second refusal and maybe make a blow up of your deposit and say, here, look, that is actually what we're talking about, to make sure it's going through. And the don'ts are all pretty much basically related to do not start talking to us about other IP. A lot of people do this. A lot of people will spend like 20 pages on how much they spent on their trademark and how it's a famous mark and how, everybody knows what it is. That is really great for trademark law, and you guys will care. But that is totally irrelevant to our review. It's a completely different legal standard. So please don't do that, because often when people do that, they also neglect to even go into the copyright part, or they'll throw like one paragraph, like, oh, and by the way, it's creative. So that is not a great way to go. So focus on the copyright issues. So I wanted to give you a few examples of some things that we have done recently, and things that have come before us. So this one is a logo, obviously. Many of you have probably seen it. It's the Tommy Hilfiger flag. It is a trademark. When we look at trademarks, we don't think of them as trademarks per se. We've had a lot of trademark people think that we may have some sort of problem with trademarks. We do not. We love trademarks very much. I am a lapsed trademark lawyer, so I very much love a trademark, but they are different standards. So when we look at a trademark, we don't look at it as a trademark. We look at it as a visual work, as we would with any other visual work. This one we looked at, and it had been refused twice, and we affirmed that because it was a basic, red, blue, and white, which is kind of, the colors of the country and whatnot. That Tommy Hilfiger actually went into a lot of detail about the meaning of these colors, which is something that the Copyright Act doesn't really what your symbolism is not really a thing that's going to move the meter on whether we think it's copyrightable. But apparently it's some sort of mashup of nautical flags as well. So that is what they were saying. But we said, regardless of that, we don't think it's going to be copyrightable. But we don't always reject logos and trademarks. We're pretty even-handed, I think. And so the next one I want to show you is this thing, we call it the Sandy Starfish. It is a starfish, and it says Bigger's Bay in the kind of this old English font. Font we don't find to be copyrightable itself, and normally every time we're not going to register a geometric shape. However, we actually reversed this one, and we reversed it because the starfish was not just a star. If you look kind of closely at it, it is kind of jagged, and it's not symmetrical. And so when we looked at that particular star, we thought that it barely crossed the line, because we know it's only a modicum of creativity, only a spark. So we thought it just barely made it over. Sometimes when we reverse things that the registration program has said we shouldn't register, we will hit a note in the letter saying we think it's got a thin copyright, or it should not preclude other things. So this one, I believe we mentioned, this is not a thing that's going to preclude starfish or stars, but this particular one we thought was enough. We have this other one called Intel Spiral. Anyone from Intel here? You can see, no? So the Intel Spiral was a very interesting matter that we had, where they had two claims. They had one in the musical composition and one in the sound recording. The musical, I will play it for you because you will all know what this is. This is like in your brain. Okay, so we all know that, right? That is like with us. So very famous, obviously, sound mark, I would say. But we looked at the musical composition, and there are not that many notes. It's dun, 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 dun. It's like 6 notes, right? So we looked at it and we thought, we really don't think that musical composition is copyrightable. But they had a second claim, the sound recording. And when we listen to it pretty closely, you'll know that there's a kind of a swooshing sound. There's kind of a layered effect. It wasn't just one kind of like a piano playing it. There were a lot of different kind of synthesizer kind of arrangements in there. And so we actually registered the sound recording. So sometimes you can get different things. Oh, I don't know what's happened. Here we go. This is the next one. This is called Tricorn, and Tricorn is a work of art. And if you see on the on your right, that is the deposit we got. It is basically a triangular, I think it's called a tetrahedron or something. That is the shape of it. But it's basically an installation piece that is a three-dimensional triangle, and it has some netting and some kind of netting over it. And in the bottom, it has some. So you see those circles? Those are lights that come out of it. And we looked at it, and we thought it barely made it over the line because of the arrangement of the lights in there and the combination with the mesh fabric. It barely made it over there, so we actually found that was copyrightable. Oh, that's it in action. Actually, as a water element that we did that wasn't part of the claim, but it's beautiful. It's in DC if you ever come and see it. So we did reverse that one. We have a couple of dinosaurs, as I mentioned earlier. People like to try to register dinosaur skeletons for some reason. And so both of these, actually the one on your left just came out in the past month. The first one is a Stegosaurus. And the New York Museum of Natural History tried to get a registration for that because they said that they didn't have all the bones. One of the bones was like a kneecap. And they said that they had modeled that one. They had molded it. It wasn't the actual kneecap. And so they should get protection for that. We said, no, that is not a good idea. We are not going to do that. And then same thing with the tail, the back. The second one is basically from a pretty common dinosaur, and it's just the tail. And they also tried to get a registration, and we said, no. There's actually a very interesting backstory to dinosaurs and copyrights if you're interested. There's like a whole copyright lawsuit about them, and there's a film that was at Sundance about it's a very interesting background, but it does not relate to our decision on copyrightability. And then this is the patent application. So we will let you give us things that have trade secrets, and you can redact them. However, it cannot be the entire thing. So this is an example of what happened. So the original deposit, it's on your right. It literally just says redacted, and there were like 30 pages of that. And so we said, no, we actually have to see something. And so we asked them to supplement their deposit, and they did with the second one, which has, this little cutout. And they're like, well, there you go. Now you can tell that it's copyrightable. And so unfortunately for them, we said, sorry, you have to actually show us something when you do it. So that was kind of an interesting foray into patent world. This is jewelry. I'm going to go a little quickly. We have a lot of jewelry claims, and sometimes we think they're registrable, sometimes we don't. So on your right, you see these are some earrings that are basically just hoops with some notches pulled out, and so we said, no, those are not copyrightable. But on the other hand, we have this ring that's kind of an eye with all these little dots in the middle and whatnot, and we said that was copyrightable. We also get a lot of furniture. This is an armoire set that we did a couple of, I think it was maybe like 6 months ago or so, and where they were trying to get protection for these kind of standard elements on it, for example, like the feet and whatnot. And so we said, no, those are, akin to kind of sens-faire. These are kind of typical issues in the furniture industry. And this is one we got some press on. This is Kanye West's shoe that apparently is $3,000. And we actually did register this one. And a lot of people ask, about this particular one. It's not the shoe that we registered because that's a useful article, but it's the actual design. And fabric designs we do register. And this one, if you see, it's got kind of a jaggedy pattern. And then there's this kind of black half a circle thing on one side, and so we thought it barely made it over. But it's not the shoe, it's that specific fabric pattern. So if you can imagine it kind of distinct from the shoe itself. And with that, I've got a couple for you to become the board, and you can tell me what you think. And they're not real, I made them up. It's my, my day job is not fun enough, so I go ahead and I make fake copyright works. Okay, so this first one is Reed Architecture. It's a logo. It's got some squares. It's got some colors. What do you guys think? Who thinks it's copyrightable? Who thinks it's not copyrightable? Ah, interesting. Sometimes it depends on the audience. If it's a trademark group, sometimes they might think it's a little bit more copyrightable. This next one is a piece of art. It's modern art. It's called The Riddle is Solved. And so it's kind of a blackish grayish background with, it's got kind of a lozenge looking thing, a circle, and that's supposed to be a triangle that's kind of faded in the back. So who thinks that that is registrable? And who thinks that isn't registrable? Interesting. So it's kind of got like a 50-50 situation there. Art, one thing that we happen upon a lot is that people will think if it's art, it's copyrightable, just because art should be. And in the Copyright Office, there is, a limit to that. And so if it is just kind of black and nothing else, we are not going to register it, even if it, evokes the despair of your heart or something, we're not going to register it. So, no matter how much of a tortured artist you are, but you have to have some actual creativity that we see on the screen. And we are great art lovers at the Copyright Office. And then this is a piece of furniture. So who thinks this is registrable? Ah, really? Because it's a useful article, so we have to have some separability. So the separability there is kind of like this thing on the top. And then if I add this, what do you guys think? Is that registrable now? Yeah? Okay. Well, so those are the examples. So now you can, apply to the Copyright Office and maybe one day be on the board and discuss these things with us. Before I go, I just wanted to give a little plug. We're having a conference in February that we're co-sponsoring with WIPO on artificial intelligence, which is all the rage, but not many people have had a whole day on copyright and artificial intelligence, which is what we are going to do. So please keep a lookout for that. I think we're going to announce the date next week, but it's in February, and we will be live streaming it if you can't make it to DC. And with that, I will turn it over to Wendy.
Okay, so before I get started, how many of you have been before the Trademark Trial and Appeal Board before? Okay, so a good number. That's good. So today I'm just going to kind of give you an overview of what a proceeding or before the board would be. The board hears two kinds of cases: ex parte appeals. Those are from examiner refusals. But today I'm going to be concentrating on inter partes proceedings. So that's when you want to oppose an application that's been approved, or you want to cancel a registration that is on the books. And just as background, I am an interlocutory attorney, and for those of you who don't know what that is, that just means I can decide a whole range of motions and issues, but I can't decide the case at final. So at that point, you would have a panel of judges deciding your case. So it's kind of like a magistrate judge, but not quite. Okay, so anyway, today I'm going to go through what it's like to go through discovery, and I'm going to give you some tips on how to handle discovery, trial, and trial briefs. There's a section about recent case law where I can guarantee we won't have time for that, but it's there, and I guess maybe you can reference that later. Okay. So this is just a list of some of the rules and statutes that apply. In particular, I want you to note the Trademark Trial and Appeal Board Manual of Procedure, the TBMP. That's a really good source to go to. It's available online if you've never seen it. It tells you what proceedings are like before us. It gives you all of a bunch of cites to case law and statutes. So it's a good source, a good place to start when you are filing your proceeding, your cancellation or your opposition. Okay, so now we are first going to look at discovery. So some of the issues with discovery before it ever even gets started is that we sometimes have pleadings that are insufficient or are incomplete. So nobody knows what they need to concentrate on. So my tip to you is that if you see a pleading and it's unclear to you what's being pled, even though they've said likelihood of confusion or they said dilution, it might be something else, and it's unclear to you, one of the things that you can do, besides just filing a motion to dismiss for failure to state a claim or a motion to strike a certain defense, you can ask for board participation. And you can make a phone call and ask for the board to participate in what I'll go through next is your discovery conference. And in that discovery conference, the board will help you clean up those pleadings. And so you don't necessarily have to file a motion, you just have to ask for the board to participate. So then, just as a reminder, the board has a standard protective order, and that covers the exchange of confidential information and some other things, and that is automatically imposed the moment that the proceeding is instituted. You don't have to sign it, it's already there, but if you do want to modify it, you can negotiate that with your adversary and then present that to the board, and then you'll have to wait for us to approve or not approve that. And then once the proceeding is instituted, you'll get an order from the board, and it'll have a schedule which looks a lot like this, giving you all the deadlines that'll be coming up. Okay, and so then one of the first things that you have to deal with is the discovery conference. And so both parties are responsible for scheduling that conference, and the topics you have to discuss, of course, are how's trial going to proceed, how is discovery going to take place. And again, if you think board participation would be beneficial, all you have to do is ask for that, and then the board will convene a teleconference with both parties on the line. And it's helpful to have board participation, and I handle a lot of those, well, almost weekly. When you have a pro se party who maybe isn't familiar with the board rules or what it's like to go to trial, it's also helpful when you're trying to clean up the pleadings, and it's also helpful when you have an adversary who is perhaps maybe more adversarial than is necessary. You can get the board on the line, and sometimes they're a little more cooperative once somebody gets on the line with them. Okay, and so then after you've had your discovery conference, the next deadline that you'll have is your mandatory initial disclosures. And in those disclosures, we are just looking for identification of witnesses and documents that you might be relying on and that have discoverable information. You don't serve that on the board, you just serve that on the other party. Okay, so then now we're into discovery. And so what I want to remind you is that the board has very limited jurisdiction. All we are looking at is whether a mark is registrable. That's it. So we don't look at infringement. We don't look at false advertising. So when you are serving discovery, you have to keep in mind that we have a limited jurisdiction. We expect your discovery request to be proportional to the needs of the case. So in other words, discovery before the board cannot be a fishing expedition. We do allow some leeway for you to ask for discovery that might lead to other claims, but those claims obviously have to be able to be brought before the board. So keep that in mind. A lot of times people try to use discovery before the board as a way to determine if they maybe should file a court case. And if you start to get out of hand, you're going to be faced with motions, or the board is going to deny your discovery requests. So just something to keep in mind. Okay, so here's just a little more information about discovery and the limits on discovery. We do allow electronically saved information is something that we cover in discovery, and Section 414 of our TBMP covers all kinds of issues with discovery. Take a look at that if you're ever before us, so that you can get a handle on our limits. Okay, so with discovery, and we've issued some new rules in the past year and a half. So when you serve discovery on the other side, you have to give them enough time to respond. And responses have to be due during the discovery period. So that means when you serve discovery, there have to be, counting the day of service, you have to have 31 days left in the discovery period. Otherwise, you'll be faced with a motion, or your discovery request will be considered untimely, and then the other side doesn't need to answer. So that's just something that you'll need to keep in mind. Of course, if you think you want to serve discovery and you're coming up on a deadline, you can, of course, file for an extension of time. And we're pretty generous with those, but there is going to be a limit. We won't extend forever. So anyway. The next deadline you'll have is expert disclosures. Expert testimony is pretty rare in a board case, so we don't normally have them, but when you do and you think you're going to use an expert, you need to, this is one of the few instances where you need to notify the board. Because what we'll typically do then is suspend proceedings so that you can take your expert depositions and whatever expert reports that you need to get. We understand that it takes a long time to do that. But like I said, they're pretty rare before us. Okay, so now we're at giving responses. If you're served with discovery and you feel you need to object to that discovery as being overbroad or not proportional to the case, you'll need to make sure that your objections are stated with particularity. So boilerplate objections will often be overruled, and so then you'll be forced to answer the question. So be as particular as you can, because what you don't want is to have the board guessing why you're objecting. So just to say that it's overly broad isn't enough. You need to say it's overly broad because it asks for use, all over the world as opposed to just in the US or something like that. Anyway, so just keep that in mind. Okay, so when you are in discovery and there is a dispute, there are a variety of motions that you can file. One of those motions is a motion to compel initial disclosures. Like I said, you are required to provide initial disclosures, but many times people don't. And so without providing initial disclosures, you can't then move forward with discovery. So that's one of the motions that are available to you. Another one is a motion to compel your discovery responses. The requirement for this motion is that you have to show that you've made a good faith effort to resolve the dispute before involving the board. That means talking to the other party, trying to limit the number of discovery that is in dispute. So to say that I'm not satisfied with these answers, I'm going to file this motion to compel, and I'm going to compel them to respond, give me supplemental responses to everything that I've ever served them. That's going to be denied because it's too broad. It doesn't show that you've tried and you've made an effort to reduce the number of matters in dispute. And also, when you file your motion to compel, you've got to include those discovery responses and the discovery requests, or otherwise that's another reason we'll just reject that motion to compel without getting to the merits at all. Let's see. Okay, so I think that's enough on the motions. Okay, so just as a reminder, so I indicated that you could have a board participation in your discovery conference, but you can actually have board participation at many steps along the way. So if you say you filed a motion and you need to a motion to quash a deposition, and so that deposition is coming up soon. You can ask for the board to participate or to handle that motion on the phone so that you can get a quick resolution. Sometimes, like say for the motion to compel, you've tried to resolve issues, and the other side is just being so adversarial you just can't get anywhere. That's another instance where you could ask for the board to participate, and maybe we can get both parties in line and more cooperative, and again, handle your matter quickly. Now, just because you've asked for board participation doesn't mean that we will participate. We will only do it if we think it advances the case, or if it's the kind of motion that is properly resolved on the phone. That's not always the case. Sometimes what we will do, though, is hear your arguments on the phone, and that means the matter is before us, and we can handle it a little bit more quickly, rather than it just, staying in the computer or in my queue and waiting for somebody to look at it. So anyway, that's one of the things that are available to you. So now discovery is over, and we are now in trial. Okay, so before trial starts, and actually, this is something you really should talk about before in your discovery conference or sometime way before trial starts. You need to discuss whether you really want a full-blown trial. The board has available to you something called accelerated case resolution, or ACR, and that is a way for the parties to agree to certain efficiencies. So you can decide, we don't want to take years to get this resolved, we want to do it a little bit faster. So the ACR track is faster, and it gets our eyes on it a lot faster, and the judge's eyes on it a lot faster. And that is a way for you to cater a trial to your needs. So you can say, we're only going to take 3 witnesses each, or we're going to, no one's going to use experts, so we don't need those deadlines, and we don't need that time frame. And so you can shorten discovery, you can shorten the trial time. So there are a whole host of ways that you can meet your needs and still get the matter expedited. So that's one of the things you need to think about when you trial's about to start, or certainly before trial, and then see if that's something that could work for you. Of course, not all cases will work with ACR, particularly cases that deal with, say, issues of intent, say like fraud or bona fide intent to use. So sometimes it's not available, but if it is very helpful, and it does speed up the process. Okay, so then when you're in trial, you have to, of course, exchange pretrial disclosures, and in this instance, unlike your initial disclosures, you do have to disclose the witnesses that you are going to rely on, but we do not require that you disclose the documents that you are going to rely on. And so sometimes the issue is that you have a witness that wasn't disclosed in pretrial disclosures, and then your options then are to move to quash the deposition, or if that testimony is already been taken, and particularly by declaration, and it's being submitted now as trial evidence, you can move to strike that, and you can also move to strike their pretrial disclosures. Those are just options you have so that you're not surprised at trial. And then here's just some information about how you can create your trial record. Of course, you have testimony by deposition, and now the board allows testimony by declaration at any time. You don't have to have that by agreement by the parties. And then you can also have notices of reliance, and that's usually material that is self-authenticating, internet materials, printed publications, official records, or printouts from the PTO website. And that's just a little bit more information here about what you need to do for that evidence. Make sure you associate it with one of the claims, likelihood of confusion or dilution. Just a little bit more information, but looks like I'm out of time. So here's just real quick on your brief. When you get to filing your trial brief, the key takeaway here is to keep it concise and keep it to the claims that have been asserted. A lot of times people waste a lot of energy talking about their company's history and how great they are. Wonderful. But that has nothing to do with the trial. So if you are looking at likelihood of confusion, go over the likelihood of confusion factors. Don't spend a lot of time about how this person or that person is a bad actor. Really try to keep it focused so that the board is clear about what you're arguing, the other side is clear about what you're arguing, and then we know what is at issue and what needs to be decided.